Good afternoon once again, Your Honor. My name is Stefano Pretrial, and I'll be arguing the pretrial motion on behalf of the defense.
Thank you.
All right. Your Honor, this case is as clear as it gets. My client, Ray Concha, had a reasonable expectation of privacy.
If this is a clear case, then I don't have a role here?
Of course you do, Your Honor.
Okay.
Just here to show you that it's clear. Had a reasonable expectation of privacy that was violated when Officer Doherty chose to overstep the bounds of the Fourth Amendment, conduct a warrantless search of my client's car. And the observations made by Officer Doherty in the course of that search was not observation of objects that were in plain view, and therefore must be excluded from tonight's trial, or this afternoon's trial. Now,
So, counsel, let me just, so what exactly are you moving to exclude here?
we're excluding the officer's testimony of what she saw in my client's car.
Okay.
May I proceed, Your Honor?
Yes, you may.
Excellent. Now, Officer Doherty did not have the legal authority to look inside my client's car in the manner in which she deliberately chose to do so. Now, cases like U.S. v. Copeland, People v. Rogers, and U.S. v. Dunn have all set the legal framework.
If you want to address yourself first, the first thing that this court has to address is the issue of whether your client has a reasonable expectation of privacy. So if you could, to the items that are subject to his or her testimony there. So if you could address yourself to that issue, the court would appreciate that. Because I think that's a starting. You would acknowledge, counsel, that under the Fourth Amendment, that unless your client has a reasonable expectation of privacy, your case is lost, correct?
That's correct.
So if you could address yourself to the reasonable expectation of privacy argument, the court would appreciate that.
All right, well, I'll address your question in two parts. Firstly, I'll analyze what were the facts in this case, and secondly, I'll talk a little bit about constitutional precedents in court cases that will support our statement that my client was expecting some degree of personal privacy. So what we have in this case tonight was the officer chose to look inside my client's partially open tinted windows. What the officer saw in plain view, and only in plain view, was a jacket and a backpack. What the officer did after this initial plain view search, or plain view look, was a search, because the officer climbed onto my client's car, my client's personal property, and conducted a search of what was not in plain view.
If you could just address yourself to the law first before that, so
Yeah.
that I could understand what law you're expecting me to follow, and so that I can apply the facts to the law that you think is applicable here.
Whatever works for you. Well, we're really looking at Katz v. United States.
Time out. Stop time. Don't ever say to the judge whatever works for you. That's disrespectful, and you just the judge gets the right to set the course of the argument. And so if you say whatever works for you, as your coach would tell you, you'd be facing a hard time. Start time again.
Well, we're looking at Katz v. United States, and in that case, there was a standard that was set, a two-part standard. Firstly, the person involved has to show an actual or subject expectation of privacy, and secondly, this expectation of privacy needs to be viewed as reasonable by society at large. So, taking that back to today's case, my client left the items in a place that was not in plain view. Now, the fact that the items were left in a place that was not easily viewed by an outsider in a car with tinted windows shows that my client...
What is the significance of the tinted windows if in fact the window is, from the facts in the case here, the windows are opened, a couple inches, and whether it's an inch or 3 inches or 5 inches, what's the significance of tinted windows if the window is open?
Well, tinted windows block plain view to some degree.
To some degree, what does that mean, counsel? To some degree, if the windows are open, whether it be an inch, 3 inches, 5 inches, What difference does it make to the analysis if the windows are tinted or not? You would acknowledge that someone could see into the car since your tinted windows were not completely closed, correct?
Well, they can't see completely into the car. And as the officer put it as the facts say, the officer only saw two things in the car. So the fact that...
But I'm asking you, you're relying on the fact that they're tinted, and I'm asking you if in fact they're tinted but the windows are open, then it seems to the court that the fact that they're tinted has no, significance. Well, I'm asking you, what is the legal significance if in fact the windows are ajar, and you can see into them, whether it's an inch or 3 inches?
Well, we believe the tinted windows and the fact that my client tinted the windows indicates that my client expected a level of privacy. Now, the level of privacy isn't just extend to windows.
Would you say that level of privacy is compromised by the fact that the windows were not completely closed?
It's compromised to the point of what the officer could have seen in plain view. Anything beyond plain view is not compromised.
But that would be true whether the windows were tinted or not.
Well, it was dark outside, Your Honor, and the fact that the officer could only
But
see...
what he could see into, what I'm saying is, what he could see into the car would be there whether the windows were tinted or not, correct?
Well, yes, the officer could have looked into the car, but the degree to which the visibility to the officer was available with tinted windows versus non-tinted windows, it shows that there was an expectation of privacy.
You can move on.
When Officer Doherty looked inside the car through the partially open window, all she saw was a blue backpack and a jacket. Now, those items were in plain view. But then Officer Doherty chose to go further. She chose to climb onto the car and thus go beyond plain view to uncover what else she could find. She was fishing in the dark, and she was fishing in unlawful waters. Officer Doherty's actions cannot be justified because she had neither probable cause nor exigent circumstances that would permit a warrantless search.
But Counsel, so what case are you supporting this second argument about that Officer Doherty had no right to step onto the car there because in fact he did not intrude upon the car, correct? He did not put his hand into the car, correct?
Not put it into the car.
Essentially, he just got a better vantage point, correct?
She did get a better vantage point, but...
So therefore, if all we're talking about here is a police officer getting a better vantage point and not breaking the plane of the car, why is this an illegal search?
Well, what we need to understand is that the better vantage point was acquired unlawfully because the officer crossed onto my client's personal property by climbing onto the hood of the car, which is not a public space. And going back to your original question, where we're coming from with probable cause and exigent circumstances or emergency circumstances, cases like Arizona v. Hicks and Kilo v. U.S. State that all defendants have a reasonable expectation of privacy, and Arizona v. Hicks states that you need probable cause to conduct a search. Now, bringing back to this case, officers saw a blue backpack and a jacket.
Counsel, didn't this officer have several conversations with your client, during his undercover operation, where your client was talking about getting him some, to see whether he wanted to get him some Adderall? Is that correct?
I can't speak on that. I'm not too sure.
Well, that's in the facts of the case that in Officer Doherty's witness statement about what conversations he had with Mr. Concha about with Mr. Concha said that if you want some Adderall, I can get you some. Correct?
That's correct.
So therefore, this officer is not coming to this with a clean slate about what might be going on here, and also, isn't it true that he saw him coming out of the market with baggies? Correct.
The officer did witness my client coming out with baggies.
And so, so we're not talking about, an officer who is just, on a, as you say, on a fishing expedition, because he did have, conversations with your client. He did see your client coming out with baggies which have street lingo that Adderall is put into those plastic bags, correct?
Yes, Your Honor, that is correct.
So then there is information here that might give cause for probable cause, correct?
Yes, but what we must understand is that probable cause isn't the only factor that can be looked at by the court in determining whether or not the search was indeed lawful. There are other circumstances that need to be met. For example, going to the second part, exigent circumstance, there needs to be some sort of emergency circumstance that warrants the police officer to search that vehicle or even conduct a search of anything at that time because there was an emergency on it. That's is ruled in a matter of welfare of the BRK. The court ruled that the client has, or the defendant has, a reasonable expectation of privacy, and that officer should have received a warrant because there was no exigent circumstances.
So, counsel, what would you have expected this police officer to have done when this he comes to the market? He's not expecting Mr. Concha to be at the market there, but all of a sudden he's there. What would you expect Officer Doherty to have done in this idea of exigent circumstances to prevent Mr. Concha from getting into his car and driving away? Therefore, any evidence would have traveled away in the car. What would you wanted the officer to do at that point?
Well, if the officer wanted to search the car, because that wasn't really an emergency circumstance, it was simply an opportunity for the officer, he should have gotten a warrant. But what the officer is entitled...
Counsel, I'm asking you the question, if your client comes out of the market and gets in the car and drives away, all the potential evidence is driving away with him. Correct?
That is true.
So then, what would you have wanted this officer to have done at that point, when all of a sudden he's presented with something that's going on, and a potential crime is there, and he's and your client is going to get in the car and drive away. What would you have wanted this officer to have done?
Well, the officer shouldn't have climbed onto the car. The officer should have waited for my client to get out of the supermarket and engage my client in conversation to discover if there was indeed probable cause. At that point on, it was determined that there was an emergency circumstance because of the conversation held with my client, that there were indeed drugs inside the car, because in plain view there were no drugs. Then that could have been a different story. But what happens as of now is the officer believes that there could be evidence. So there is no solid evidence or emergency circumstance that popped up that guaranteed evidence was inside my client's car. So conducting a search where there was no exigent circumstance or very little probable cause is unlawful.
Yeah.